Okay, everybody. So again, thank you for joining me. Today is December the 6th. This is training number 9 for the Family Forward Project. And it is knowing the difference between laws, rules, regulations, and policies. Oh, now as you take a yawn and you say to yourself, well, this sounds like it's going to be pretty boring. I will admit it's a little bit of a boring topic, but it's so critically important. And as I'm preparing these trainings and I kind of think of topics and how to pull topics together, I think about my own experience and the way I've traveled through learning more and more how to be a better CPS litigator. But I also think about, people who still call me and want me to kind of help sort out what's going on, know what their rights are, etc. I still have to sort of explain to people the difference between laws, rules, regulations, and policies. So I'm just like, okay, we're just going to do a training on that. So here we are. And the first few slides was kind of slipped through fairly quickly, but and you don't have to take notes because I do share the slides, but you might want to jot a few things down just so you understand this distinction. So before you step into the unknown of child welfare litigation, you have to know the difference in these. You've got to know the difference. That's why we're doing this today. So the problem is that parents and advocates are going to hear references to laws, regulations, laws, and policies. And without knowing the difference on how these interplay, the state agencies will continue to manipulate you with their quote unquote authority speak. Now, I've added this little diagram here just to give us something more interesting to look at. The heights of these mean nothing, okay? So it doesn't refer to something having more power than the other. As a matter of fact, you're going to find, as we talk about it, that they kind of bounce around. There may be in a certain situation where the policies are more important. It may be that the rules or the regulations or the laws are more important. So it's just kind of for you to keep in mind that they are totally different. Laws, policies, regulations, rules, they're all totally, totally different. And we know how the state agencies and attorneys love to act like they're smarter, right? And I'm just going to give you a quick example. I walk into a courtroom years ago representing somebody and they're like, I asked to do something and they're like, well, our policy won't let us do that. And I say like, okay, what's the policy? And nobody can tell me. On the other hand, when I ultimately figured out how to use this to my advantage, I had a situation where I wanted the parent to have a support person in the perm plan meeting with them. And they tried to kick him out and they said, oh, it's confidential. And had already pulled up the policy and I says, well, the policy says that a parent can have a support person. So that is why we have to just kind of keep educating ourselves on what those mean. And not only are there laws, regulations, policies, and rules, there are also state and federal. There are federal regulations, federal laws, federal policies, and there are state. So as you are trying to find your way through CPS litigation, you are always need to identify, are you working with something that is a state policy or a federal policy, and how does that affect your case? All right, so state versus federal. So the federal ones are the United States Code, which is referred to as USC. If you see USC written down, I'll give you a very good example. A lot of people know about 18 USC, or I'm sorry, 42 USC 1983, which is a civil rights code. And so the USC stands for United States Code. The CFR, the Code of Federal Regulations, is then created by the state agency, and Congress gives the state agency the power to create these regulations. And then policies and technical assistance are created by the Administration of Children and Families, and that agency is sometimes referred to as ACF. So you may see an ACF technical assistance letter or something of that nature. In the state level, again, you have laws and you have statutory laws versus case law. You have rules, which are primarily, we're going to be looking at procedural evidence and agency rules. and you have policy, which is created by the agency. And then you're also going to have this other kind of lower level, and it doesn't hurt to try to find it for your particular state. Sometimes they call it a best practices guide. Sometimes they call it standards of service guide, but there's going to be something about at the state level that they create within the agency of kind of the what they're supposed to do, although they often don't even follow their own rules. Oops, sorry about that. We don't want to see what's going on there. Federal. Okay, so now let me make sure I didn't skip one here. Yep. Okay. So federal, you have U.S. Code, Code of Federal Regulations, and policies and technical assistance. Now, in child welfare, we're going to have U.S. Code. I think I have another slide for that established the requirements for the state to have plans to implement Title IV-E. And then from that, the agency created regulations. Also, with the president at the federal level, there is the ability of the president to write executive orders in child welfare. The first time I ever saw an executive order was under President Trump on May 24th, 2020. And this was, I mean, the president's, HHS is the president's agency. So the president has the authority and the obligation, responsibility to control the effectiveness of those agencies. So he wrote this executive order primarily about the data collection, but it also covered some other important issues. And one of the most important things is in the very first sentence or first paragraph, he says, the best foster care is when one is not needed at all. So federal laws have to be passed by both houses of Congress, and it is sent to the president after they've both signed it. This is found under the U.S. Constitution, Article 1, Section 7, Clause 2. The president signs it within 10 days. If it lays on the president's desk for 10 days without a signature, it then can go back to Congress and be passed by 2/3 of Congress, both the House and the Senate, and then can become a U.S. code. So laying on the desk is sometimes what a president will do if this happens a lot when there is a difference between the balance of power. And if you have a Democrat president and you have a Republican Congress, and sometimes the president will just allow things to lay on the desk because he doesn't want his party to appreciate that he has signed off on that legislation. So the federal regulations under CFR, the federal agency is given the power to create the regulations by Congress to implement the laws. And these are recorded in the Federal Register. It is called the Code of Federal Regulations. So for child welfare, 42 U.S.C. 671 and 42 U.S.C. 673 are the federal codes are laws for CAPTA and ASFA. All right, so I'm going to stop here just a second. All right, so as you know, we at Family Forward are trying to get a bill passed for the Advocates for Families Act of 2024. This would be a Title II law. So we are trying to get it passed by Congress and signed by the president so it becomes a law. So it is written into the code. And it would not be a brand new law because it would be written into the code that already exists for Title IV-B execution. And then 45 CFR 1355, 1356, 1357 are also the requirements of Title IV-B and Title IV-E. Now, you want to be a real nerd, you can go read those. I have read them all, of course. And it does have some interesting things. I mean, it tells you some of these things that they're not doing, right? About under CAPTA, they have to make a finding that it's contrary to the welfare of the child to not be returned at a preliminary hearing. Well, they're supposed to make findings that it's contrary to the welfare of the child. And what's happening at the lowest level of the totem pole in the juvenile court system is the judges are just writing an order that says it's contrary to the welfare of the child. I think this is an absolute breach of the law. And this is one of the things that we need to fight against. Under ASFA is where, of course, they require the termination if a child is in foster care 15 months of a 22-month period. They require the filing of the TPR. They also have certain requirements as to some relative placement issues are in there, and also the grounds for termination. The CFR, again, is just a lot of more of the details of the implementation of CAPTA and ASFA. You want to be a real nerd? That's the place to go to just start reading. I'll probably just read them all on the record at some point. Then you can just listen to it. Okay, so the rules. So when we say rules, rules has a lot of meanings in law. We have a lot of meanings for the word rules. Generally, rules are going to either fall under rules of civil procedure, rules of evidence, federal local rules, federal rules of appellate procedure. They're going to be primarily rules about how the CPS litigation functions. So if you have watched my prior trainings, we have talked quite a bit about evidence, and we have talked about witnesses, and we've talked about hearsay, and we've talked about authentication of records. All of those come under the rules of evidence. Now, not the federal rules of evidence because we're in state courts. However, most states follow pretty closely the federal rules of evidence. So I would recommend that in your own state, you go through and you pull up, and you can find them all online now. You pull up your rules of evidence in whatever state, Tennessee, Alabama, wherever you are. But you also start taking a look at the federal rules of evidence, because they're going to, if somebody reaches out to you in another state, you can pretty much be guaranteed that the rules of evidence are going to be pretty similar with the federal. Now, with that said, there are, of course, a lot of nuances between each state. So if we get more detailed in that, we'll talk more about that later. Policy. So the Administration of Children and Families creates a couple things. They create this thing called a technical assistance. They create guidance, and then, of course, they either respond or they implement executive orders. And I'm going to give you a couple of examples. In 2015, this is a very good thing to research. You can Google it and you can find this. If you're dealing with anybody with a disability, the Sarah Gordon case out of Massachusetts was a case in which the mother had a mental disability, and they took her baby away from her, and the girl's mother, so the grandmother of the child, came in and said, I will help raise this child. And they said, oh, no, you can't do that. And so HHS and the Department of Justice came in and they said that that was a violation of the Americans with Disabilities Act. So they came out with, first of all, just an opinion letter. And then a couple months later, HHS and ACF created a technical assistance guide on how to deal with parents when there are disabilities. We're going to do a whole training on disabilities because the states are going nuts over disabilities. They're trying everything they can do to shut down application of ADA, and they have no immunity under ADA. If it's a constitutional right, we're going to have to do something on that just for ADA because it's so important. All right, then let me give you a second one that also relates to the Administration of Children and Families. In December, I think maybe 2019 or 2020, the Administration of Children and Family also published another technical assistance guides to the states, which told the states that they could use Title IV-E money to help reimburse attorneys who are representing parents. And it was like a 75% reimbursement or something, which basically would have provided more money for parent defense. A few states took this money, most did not. And Tennessee did not. And it's shameful, the states that did not put this technical assistance into implementation. All right, so at the state level, and honestly, most of the advocacy work is about state laws, but so many of the child welfare laws are there because of the federal laws. So you have laws. They can either be statutory laws or they can be case law. You can have rules. Again, you have procedure, evidence, agency, rules. You have policies created by the agency, and you have this best practices guide, standards of service guide, etc. Now, notice a little bit different here under rules. I don't have regulations on here. I have rules. That is because they are regulations, but they are called rules. And the distinction is that it is the agency that creates it, not the legislature or the courts. So state laws, so you have statutory law and you have case law. And I'm also going to tell you this. You know what? When I started law school, it's been several years ago, more than 3 decades ago. However, when I started law school, I did not even know the difference between statutory law and case law. So if you know this, you're way ahead of more of a lot of first-year law students. So statutory law is created by and passed by the legislative branch of the government. It is signed by the governor. If there's no signature in 10 days, it becomes law. Now, this is specific to Tennessee. However, most states have a very similar provision, and this would be written into the Constitution. You might want to take a look in your state. Does your Constitution provide that if the governor fails to sign it, it's passes by basically laying on his desk? Case law is created by the courts, and the courts are supposed to interpret the law, but in the course of doing so, they are often writing new law. Very, very, very frustrating for me in the process of being a lawyer of what I have seen the courts do to law that legislators think is black and white and then becomes all muddled up once the courts have access to it. You know, uh, trying to think of maybe, well, my case is a good example, basically. So in my case, they created an indictment that removed an essential element of the crime. Now, you would think that would be black and white. You would think that it would be a faulty indictment if it did not include all the essential elements of the crime. And so as I was studying, as I was appealing this, and I went through case law and statutory law, I mean, the law says things like, the indictment shall state that what you're being indicted of, but it does not say that you have to put every element of the crime in there. And our Tennessee court system actually said, in my case, that you did not have to have all the essential elements of the crime in the indictment. So basically, that means that every single indictment that goes to the grand jury is either founded or based on fraud very easily. All right, so also for statutory law, you're going to find the statutory law in the state code, the code. So it'll be the Tennessee code, the Alabama code, the New York code. That's going to be pretty consistent in every single state, the California code, the Texas code. Okay, so if you want to find the CPS code, you will just, and I've got a little sample of that here in another slide, but they have almost all of them online now where you can get that code. So you can pull up the Alabama code and you'll see there are different chapters in it. You can usually have drop downs for those chapters and find your way right to the sections that you need. Again, they're not easy, I'll tell you, because they're it's very confusing, okay? But it is the black and white. It's called the black letter law. That is the law. So case law is found in the cases. Now, I use Lexis to do research. I do have to pay for it. It is very sophisticated. I've used it for many years, and that's why I just keep Lexis. But you can find it just as a pro se litigant or an advocate, and you want to perhaps pull some information. Let's say you want to work on the case law for termination of parental rights, and it'd be great to have some projects, people working on projects such as what does termination of parental rights look like across all states, where we can find a lot of the case law in case text. I keep my eyes open for case law that's coming out of certain states. We've had people have been pretty good, and that's one reason why we have the Family Forward Project, because things will pop up on there and then I will keep them. There was Pennsylvania and a New Jersey case, and honestly, I'm just going to tell you, I can't tell you what they are off the top of my head, but one of them was or which was which, but one of them was about using anonymous reports to instigate a search warrant. And I believe that was the Pennsylvania Supreme Court that said you could not use anonymous report to instigate a search on somebody's home. Now, of course, you can still use it to take their child. So we're not quite where we need to be, but that was an important case. Now, they will be cited. If you see them written down, it may say something like Department of Children's Services versus John Doe, or it may have like N. Ray, Johnny R., etc. That's how you're going to know that the reference is to case law. So state regulations. State agencies are given the authority by the legislative body when they're created. So all of our state agencies are created by a law, right? So the Department of Children's Services was created by a law passed in 1994 by the General Assembly, where it has a code for the Department of Children's Services, which lays out certain things, such as how it will be created, how the commissioner will be appointed, what some of their roles are, not all the detail, but they are created by a code. But they're also given the authority in that code to create rules and regulations to implement the law. For child welfare, this will also include the rules and regulations for licensure and facility requirements, but there are also some other regulations in there. They need probably more regulations related to things like visitation and placement and medical authority to treat a child, etc. They do not have those in there. And we're going to talk about where that comes in. The rules. So we also have now the regulations sometimes at the state level will be called rules. Okay. So rules, regulations, very confusing. So, but just like in federal, we have rules of civil procedure, rules of evidence, rules of juvenile court and family court, and often there will also be local rules. Now, civil procedure is about the process of the lawsuit. So it will talk about how to file, when to file motions, when to set motions, what kind of motions can be filed, what is an interpleader, what is a default, what is a relief from judgment, what is a final judgment, how do you serve a final judgment, how do you stay a proceeding. So the rules of civil procedure are all about the process of litigation. The rules of evidence, like I talked about before, is authentication of records, witness testimony, etc. Now, juvenile court and family court often have another set of rules that are not comprehensive. They do not cover everything in civil procedure. They are supposed to help make the process better and simpler and really define some of the uniqueness of juvenile court, such as dispositions, adjudications, delinquency, etc. But they honestly sometimes make it a little bit more complicated, especially for families and advocates. And then the local rules are the local rules that are created by the judges in that court system. It's more likely to include things like how many days do you have to have a motion filed before you can set it for a hearing? What kind of when do you have to provide a list of witnesses before a trial? So it's more detail typically about the process and the procedure. Sometimes the judges will include certain forms that they want used, etc. Now, state policy. This is the ringer here. All state agencies create policies. They can change these policies whenever they want. Okay. They are critical in child welfare advocacy, permanency plans, relative placements, classification, investigation, team meetings, etc. Delinquency, so much is in the policies. And as I said before, early on, I know standing in a courtroom one day, I was like, we need to do this or we need to do that. And they're like, oh, it's against our policy, right? So it's important to know policies. Now, for instance, this is if you can find this for your state where you're working, or if you're a parent or an advocate, there's going to be within the policies somewhere some type of document that defines abuse and neglect. I gave I beat an administrative hearing one time because this parent was charged with neglect. And I asked them how to define neglect, and they defined neglect as a child who was being neglected. And so, therefore, I was able to dismiss their entire claim because they didn't even have a definition for what they were seeking. I don't know exactly when they created this document, but it was probably after I raised that argument. So, this is so important. This is a must. Now, physical abuse. A lot of us think like, if a child is physically abused, being seriously physically abused, of course, they need to be protected. And we do not want child injured or killed or dead. The level of that, the source of that, there's a lot of things that, could be discussed here, but this gives a definition which basically is physical trauma, physical injury or trauma that could cause injury inflicted by a parent, a legal custodian, a relative, or any other person responsible for the care and supervision of the child. Okay, so now notice it's not a stranger, which you would think any person, and they would stop right there, but it's any person who has responsibility for the child. A parent failing to protect from another person who perpetrated abuse. Injuries can be marks, bruising that go beyond temporary redness are in excess of age-appropriate corporal punishment. I've never figured out what age-appropriate corporal punishment is. Violent behavior sorry about that. Violent behavior that demonstrates a disregard for the presence of the child. All right, so drug exposed child, this is one that is coming up a lot these days, right? The child's been exposed or experiencing withdrawal from use, sale, manufactured of a drug or chemical substance, including but not limited to alcohol. I'm sorry. Can you hear me? Can somebody put a thumbs up out there? I'm getting a weird phone call here. Thumbs up, everybody. Are we good? Okay, good. Thank you. All right, so including but not limited to, such as a diagnosis of fetal alcohol syndrome, cannabis, hallucinations, stimulants, sedatives, narcotics, methamphetamines, heroin, inhalants that could adversely affect the child's physical, mental, emotional functioning as a result of the actions or behaviors. Okay, so all kinds of sloppy language in here, such as that could adversely affect the child's physical, etc. So we have a lot of subjective judgment being made here. And of course, that's being left to social workers. A child or parent, a parent caregiver that uses drugs or chemical substance that impacts their ability to adequately care for the child. Again, very subjective. A parent caregiver that has a current addiction issues that could adversely affect the child's physical, mental, and emotional functioning. Of course, I truly, truly believe you cannot be a dead out drug addict and raise a child. It's too hard because it requires too much attention. But I also know there are parents who struggle with addiction who can be rehabilitated so that they can have a safe home for their child. Severe forms of allegations include, but not limited to, manufacturing of meth where the child is present. Actually, I totally agree with that. Now, infants born with a diagnosis of fetal alcohol syndrome, we rarely see that in the USA. In all my years, I will say my children adopted from Russia were diagnosed with that at the time. I'm not sure if they really had that diagnosis or, whether it was real or not, but they were given that diagnosis. But I have never seen it in the US. Infants born with a diagnosis of neonatal abstinence syndrome, NAS, where the diagnosis is not based on the mother's prescribed and appropriately followed medication assistance treatment. There might be something under this. Knowingly or with gross negligence allowing a child under 8 to ingest a substance. Okay, so this is, again, these are just things you have to know. For instance, I've had moms in the hospital who were tested without their consent, and they came and took the child, but they never gave her a copy of the drug test, for instance. Or they had some type of a urine test that was never sent to a lab. And I've had one that actually said that I can't remember. Oh, Suboxone. So in Tennessee, of course, it's legal to have Suboxone, which should not result in the removal of the child, but I have actually seen that as well. All right, neglect. So this is the biggie because this is where we are dealing with so many issues with the children and the removals. We know that 85% of them are removed under neglect and not under physical or sexual abuse. So understanding what is neglect. Now, I'm not going to read through every one of these, but for environmental neglect, the living situation, either inside or outside of the residence, is dangerous or unhealthy. Again, notice there are so many subjective terms in this. The impact of the environmental condition on the child, right? And then it gives some examples. Substances or objects accessible to the child that may endanger health and safety. Well, golly, that could be anything. That could be kitchen knives, right? It could be forks for that matter. I know, they have used against parents not having their prescription bottles set up out of reach, even though most prescription bottles now have child safety locks on them. Open, broken, missing windows. I think that's interesting, but that could be serious, but it may be a broken window that's just cracked, right? So we need to be very, very wary about how these things are used against parents. And an important thing about this is that what we want to do as advocates and what we want to teach parents to do is to identify the specific problem. So when DCS takes a child and they say environmental neglect, well, again, let me give you an example. The law says that when CPS initiates an investigation, they shall tell the parents what the allegations are against them. Okay. So they come to knocking on your door, knock, 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 and they say, we're investigating neglect. And the parent has a right to say, what are the allegations? That's what the law says. So they do not like doing this. And when I started confronting them about tell us the allegations, the first couple of times they actually sat down and read the referral to us, what was in the referral. And sure enough, whenever Connie forces their hand on something, they take some corrective action to protect themselves. And so it wasn't but just a few months after that I would say, what are the allegations? And they would give a conclusive statement where they would say, environmental neglect, psychological neglect, educational neglect, and they would never tell exactly what those allegations were until they served a petition on the parent. So if they allege environmental neglect, what the goal of the advocate is to identify what is that specifically. I had children removed from a home of some couple of parents who were living totally on disability, and they had to rely on a window air conditioner, and they were living in a trailer. They were paying their rent, but their window air conditioner went out, and there was a small hole in the floor in the trailer. And so instead of fixing the air conditioner in the floor, of course, they removed the children. But if we force them to identify what those specific conditions are that is causing the environmental neglect, perhaps they can be remedied much more quickly. Nutritional neglect. Oh, failure to provide adequate nutrition, very, very, very subjective, occurs when a child repeatedly experiences hunger for hours or in a large part of the day, no food is available. And these behaviors may include begging, from neighbors for food, eating out of garbage cans, or constantly stating a need for food. Now, of course, that sounds really bad. If a child's eating out of a garbage can, that is not a good thing, or if they're running to their neighbor's house. However, constantly stating a need for food, I know a lot of children who say they're hungry a lot. Even kids, what makes me very nervous about this is school, right? Because the kids can take a snack to school, but if they don't take their snack, or they just tell a teacher they're hungry when they go home, or, we don't want all of those red flags going up. So I'm very concerned about always stating a need for food. I know children from about ages, it seems like about 7 to probably 17, they are like eating machines. So always needing food is not necessarily neglect. Medical neglect, and we will do a whole training on medical for a couple different reasons, specifically some of the specific conditions that they're taking children on. But a situation that a child does not receive adequate health care resulting in potential harm, medical treatment applies to procedures or treatment that a physician or other professional deems necessary. Medical neglect does not include elective health care. Interesting, right? Medical neglect may rise to a level of severe abuse if the absence of medical care endangers the life of the child. This is a very, very, very touchy subject because it could go very broadly. It could, they haven't used it for vaccines yet that I have seen. However, I know with the schools, they require vaccines. And if you don't do a vaccine waiver, an angry school teacher could say, you're not getting proper medical care, right? There are all kinds of potential procedures or treatment, like let's say tubes in your ears, all right? I didn't have children who need tubes in their ears. I knew some children do. They have chronic ear infections. But there may be some parents who would rather not do that and who would rather treat with low-grade antibiotics or something to keep their child healthy. So, ADHD medication, psychotropic medication, we have to, what is that state where it's elective health care and when they consider it necessary? So if a parent is accused of medical neglect, then again, it's a matter of really specifically identifying what that neglect is. I had a particular case with a very disabled child who could not eat at all. And she had a feeding tube for pretty much all her life. By the time I met her, she was about 5 or 6 years old because I think she had started school. And she actually had this feeding tube and she had to wear a backpack that carried her nutrition in it with her. And she got in a school system and they you know, of course, they tried to accuse the mother of making it up, but the mother was savvy enough, I think, through her church members, actually, that she reached out and hired me as an attorney during the investigation stage. So I met with DCS with them during the investigation. And, one of the important things that we did, and this kind of covers both nutritional and medical neglect, is one of the important things that we did is I sat down and talked about what is it specifically that you want that's going to solve this? What do you need to solve the question for you as to this child getting the proper things that she needs? And we got it resolved, by the way. But it was early intervention on an attorney's part. All right, so then we have educational neglect, repeated failure of the parent to meet the child's educational needs. Any child that's in a legally mandated educational program. Okay, I can't read this, so let me have, oops, sorry. Children mandated educational program. When applying this allegation to children 12 or over, it should be considered after the inability of the school to engage the parent or legal custodian to approve attendance. Okay, so I have a real problem with truancy and child removal. I have a case in which that occurred, and even after it was remedied, of course, once they had their paws on the children, they never wanted to let them go home. And then failure to enroll school or failure to register for school could be educational neglect. Again, a little bit frightening because a lot of parents decide to homeschool but don't really take the effort to go through the real homeschool procedure. So when is that going to rise to educational neglect and something that could just be corrected? I've had DCS try to use this where I had a parent wanted to homeschool and they didn't like the umbrella school that she was using. So they were trying to use that against her. The allegation is not appropriate. No, this is so important right here. The allegation is not appropriate for reports of children who willfully refuse to attend school. Hello, hello, hello. Now, once they have their hands on the kids, they create some other fake neglect accusations. But in this particular case that I worked on, it was an unruly teenager who would not go to school, and they used that to take the other children from the home who were younger. The allegation is not appropriate unless the school has demonstrated its attempts under truancy. Again, I don't think they do it very well, but that's what we have to deal with. The lack of supervision is the failure to provide adequate supervision by the parent or custodian. And it could mean that the child is placed in a situation that requires action above the child's level of age, education, ability, or mental ability. You know, one of the places that CPS has liked to try to use this is when a family has several children and the oldest child is helping to parent the younger children by getting their cereal in the morning, helping correct them, helping keep them in line. You know, CPS will sometimes say that a child is subject to lack of supervision because they are being forced to be a parent. Stupid. Caregiver inadequately supervises the child. The parent is with the child, but unable to, hang on, I got to move this, unable or unwilling to supervise a parent under the influence of drugs or alcohol. Any registered sex offender residing in the home with an unrelated, I don't know why it says unrelated, unrelated minor child, and the caregiver knowingly resides or allows the child to be with unsupervised with a registered sex offender. Abandonment. Oh, this other one up here, though, congregate concerns that children are in congregate care facility were able to engage in sexual activity. Well, and foster care, right? That's lack of supervision because that's happened too. All right, abandonment is a deliberate absence of a parent or legal custodian with no plan or provision for the child's care. So, abandonment of the child in the child's own home. So, a parent abandons the child and leaves them in the home or leaves them at daycare. I've seen that happen. Or substitute care, leaves them with the babysitter, never comes back. Abandonment in a car, highway, or in a public place. Leaving your child in the car, of course, that would be abandonment. Child left in the care of a suitable caregiver, but without proper planning and consent, and then does not return as scheduled. And newborn infants who are ages 2 weeks or younger, voluntarily delivered to a designated agency. Okay, so that is the whole safe baby drop box plan. This abandonment, though, they have used much, much broader than this. Of course, these all sound horrible, right? You take your kid to a daycare and you leave them, which I know has happened, but they have used abandonment in broader situations. For instance, I had a case where the parents had two very young children and they had a very ill relative. And two other relatives offered to take care of the very young children while this couple went and provided basically a hospice respite care for the very sick adult person, right? And it took time. They had cancer, they were dying, but they did not want to have their children around that. And these relatives had said they would help provide that care. Well, after a couple of months, the relatives went and filed ex parte orders for custody of the children, saying that they had abandoned the children, and of course it took 2.5, 3 years to unwind all of that. All right, child sexual abuse. Of course, child sexual abuse is horrible. I think part of the investigation process, the interview process, is very lacking in many ways and very concerning. But of course, it's a horrible thing. And we have uh, abuses on both sides. We have child sexual abuse that is not prosecuted properly. And then we have child sex abuse that is overly prosecuted when there are false allegations. And then, of course, we have this narrow band when everything goes right and the person who is the alleged perpetrator is properly convicted and put incarcerated. All right, domestic violence and child death. I think these are the last two under this issue. Domestic violence, they are using this a lot against parents, and they also use it to try to split parents up. I was a domestic violence prosecutor when I first got out of law school, and I always said that domestic violence and the mind of a criminal come in three categories. They are either mean, stupid, or nuts. And if they are stupid or nuts, in other words, they just did something stupid, they lost their temper, they threw something across the room, or if they're nuts, which means they need mental health treatment or some type of serious anger management classes, that those were the ones that you could correct and get them back on course. The ones who are mean, who are really psychopathic mean, of course, they're very dangerous people, a lot of narcissistic behavior, and they are not easily remedied. But domestic violence cannot just be looked at as one collective category. It needs to be identified specifically. What are the problems? What are the issue? And I had this one couple, they were accused of domestic violence. They were ordered to go to couples counseling, which, of course, if there's real domestic violence, you never order couples counseling. But they were ordered into couples counseling. They say they had not committed domestic violence. And so they told the counselor they had not committed domestic violence. And so, of course, CPS would never find that they had completed their plans because they refused to admit that there was domestic violence, right? So, identifying the specific acts, the specific problems, the underlying problems, the roots, so that we can help these families get past this terrible, terrible, terrible situation. All right, so this is just a screenshot from the policies page. So you'll see here, and I just go to Google Tennessee DCS procedures and policies, because it's called the APP, procedures and policies. And so I just Google that and I get to a website, and you can do a drop down list. All of this just happens to be chapter 14. Now, there are lots of other chapters. There's a chapter 16 is one I rely upon a lot because it's about perm plans and relative placements, etc. But this is about, as you can see, about the investigative process. And so, we need people in each state, and you might pick 2 or 3 states to become proficient at, but to really look at what are the policies of that state and how can we use them to help a parent, or how do we turn a parent on to go in and start looking up these policies. They're so massive and they're so detailed. A parent who is in trauma can't really sit down and read through all of those, and that's why advocacy is so important, so that they have generally in their mind, like, what is neglect? What is neglect in Arkansas? So the advocate, if they don't know it themselves, they can get online and Google, what is the Workaid or the definition of child neglect in that state, and how do we define it and start remedying the reasons for removal. So there are certain policies on referrals against staff, intake assessments, services, task manual, screening and assignment, and working with hospitals. Of course, where did I see that? I think I saw that on here. Working right here. Protocol for working with hospitals. That's very frightening as well. I haven't read that one, actually, I have to confess. All right, so this is one of their policies. This is in chapter 16, as you can see there, 1631. And this lays out what this policy looks like when you open it up. So it has the subject, which is the permanency planning. And then it has under authority right here, it has what is the law. Okay, so back to law, we have TCA, which is Tennessee Code Annotated, right? So these are the laws that would refer to this. All of these touch on this issue. This is why, again, it's so confusing. And then you have down here this PL which is the rules or the regulations. So these are the public law, so let me look here over here. Oh, no, here is the code, 27 PL. Okay, these are some of the regulations right here. And then you have the rules and the permanency planning. And that is in that chapter. And you can actually Google and type in that very word right there. You can do rules of DCS, protocol, permanency plans, chapter 0250-07-01, and you can pull up the actual regulation. And then the standards, these are, when I was talking about a best practices or a standards manual, there's a standards manual out there that has these very references in it. And then the application is to all family service workers. Now, here's their policy statement, which is real important. And it says that the permanency plan will be developed for children. Oops, sorry. Back up. Move this out of the way. During the custody adjudication. Wait a minute. I'm going to put this over here so I can see. Permanency plans shall be developed in collaboration with the youth, child, and family during a CFTM, we call it, which it's not a team. It's a DCS meeting for all children in DCS custody. Oops, got some late joiners here. Adjudicated dependent, neglect, or unruly under 18 years of age, and all youth under 19 who've been adjudicated delinquent. Okay, this is really important because this word right here, adjudicated, I need a marker. Oh, hang on here. Annotate. Let me see if I have a marker in here. Oh, I do. Look here. Adjudicated dependent neglect. Well, the truth is that parents are required to go to these meetings prior to adjudication. Okay, before they're ever adjudicated, they're required to participate in these meetings and then create this plan, force you into this plan. I'm looking with somebody at doing a whole lawsuit on this because I'm hearing it over and over and over. I did my plan. They would not give me my children back. And so I think they enter into a contract with parents and they should honor that. To provide instruction and guidelines related to permanency planning. Now, this particular policy is about 5 pages long, so there's lots of detail in here about how often they're supposed to have it, who's supposed to be there, how they're supposed to proceed, how they're supposed to classify, how they're supposed to document, etc. So these are very, very important tools. All right, now back to state law. I had talked earlier about, oh goodness, let me see if I can get my little ring off here. I can't erase my markings on my paper, so sorry about that. So this is where if you just go for Tennessee, if you just go Tennessee code, and it will give you a whole list of titles. Okay, so you see right up here at the top of this, it says Title 37 for juveniles. So this is the big book is called Title 37, and this is the juvenile code. Now, this is not the adoption code, so that's in a different book. But you can see how many different, so you have title, chapter, part, okay? So this is just Title 37, Chapter 1, Part 1. And then this is Title 37, Chapter 1, Part 101, right? 37, Chapter 1, Part 104. It's very confusing, right? But each one of these, then when you click on them, it tells you about this one in particular about concurrent jurisdiction, exclusive and original jurisdiction, informal statements without adjudication, venue, contents of petition, service of process. So this is the law that has been written by the General Assembly about how to implement a juvenile court proceeding for dependent neglect or unruly or delinquency. So the case law is either the United States Supreme Court law, which is where we find a lot of the parental rights law, the state Supreme Court, or the state appellate court. The state rules, again, we talked about this already. There are rules of procedure. Let me get this down here. There are rules procedure, which is how to file pleadings, motions, intervention, defaults, discovery, trial procedure. There are juvenile and family procedural rights or special rules regarding timeframes for hearings, disposition, discovery, etc. There's rules of evidence of how to get evidence in the record, authentication, hearsay, witnesses, privileges, etc. All right, so the people. All right, I'm going to see if I can erase that little mark there. No, I'm not. Too much work. I don't want to slow down. All right, now I don't know if you all know who this guy is here. This is a really cool judge who does this court up in Rhode Island, is always giving people a break. He's Mr. He always does such nice things for people. So I wanted to use his picture, although we know most juvenile court judges are not that pleasant. So who are the people in the laws and how do they interplay? So we have rules, regulations, and policies. And the answer to the question is, why are we the ones to solve the problem, right? So the judge's job is to hear the facts and apply the law, which could be statutory law and case law, based and reach a reasonable conclusion based upon the burden of proof. So when you go into CPS litigation, the state agency always has the burden of proof, and it's a fairly high burden of proof. It's clear and convincing evidence in most cases. So the judge is supposed to hear the facts, take notes, decide how the facts weigh out on the scale of justice, and then apply the law as to whether or not there has been abuse and neglect as set forth by all of these laws, regulations, and policies that we've talked about. The attorneys are supposed to follow the laws and the rules, the statutory and the case law, and the rules of procedure, etc. So, one of the reasons I want parents and advocates to understand this is attorneys have no patience, no time, and no ability to educate parents and advocates on what the laws are, what the rules are, what the regulations are, what the policies are. So they need to know how to start digging into those and how to use them. The CPS staff, so the CPS staff is supposed to be following all of the regulations and all the rules and policies. They're really not that educated on the law generally, except how to take children and how to terminate parental rights, how they can make up facts to fit the law so that they can remove rights forever. So other providers, the contract providers, sometimes defer to state policy. And of course, their licensure would require them to follow state regulations, but they don't really pay much attention to what the law is either. That's not their job. They're supposed to be a service provider, but you can use policies against them to make sure that they're in compliance with policies when they are providing those services. So it's very, very, very important that while advocating and for parents that they ask questions. They need to ask the questions, where can I find the policy website for the state? What are the applicable policies? What policy should I be looking at instead of just the documents they shove in front of their face? Pull the actual policy, read through it, create a notebook. I've had parents who have been so aggressive that they've created their own notebooks where they pulled off the relevant policies and put them in a notebook and hold the state workers accountable for the policies, such as having a support person. They don't even inform parents. So parents are permitted to have a support person in all of the agency meetings. They don't even tell a parent that. Otherwise, parents would be bringing somebody with them to kind of help them through that process. So how are you going to use this information? If you are not aware of the difference, the state agency will use your lack of knowledge to showcase your stupidity and undermine your efforts as an advocate. That's just the bottom line here. Some people are going to like advocates, some are not. I had a conversation with an attorney today, and I was talking to her about the training that I was doing for advocates and parents. And I said, and I've known her for a really long time, and I said, good attorneys are going to appreciate the fact that a parent is informed, a parent has, their list of witnesses together, they have a list of the documents and evidence that they want to be able to use in their case. They already understand understand about authentication. They already understand about what it's going to be like to be on the witness stand and be cross-examined, and how to help their attorney to prepare for the cross-examination of other witnesses. Bad attorneys are going to say, no, I'm not paying any attention to this. You're not an attorney. I am. And that's going to be one of the hot ways to figure out really quick whether you have a good attorney or a bad attorney. So know how to find the state law website, the rules, the regulations, the policies. They're all available online. Know how to find them. I was actually creating pages for states where I had these links. I never quite got it finished. 50 states are a lot of states, but that's a project that somebody might want to actually help with. All right, so as an advocate, there's going to be always a process, right? So our process, day one, as we look at these, as people come forward and they start seeking guidance and help, day one is when the investigation starts with the referral of abuse. And on this little gray line here, I've got the knock, talk, take, pull, sort, assess, options, plan, implement, work, reassess, and close. That's just kind of the way I see it. We might make a chart on that and help parents understand that this is kind of the process they need to go through. But with the removal, the state's going to jump in and take the child with or without a court order, often ex parte if there is a court order. By the time you make your first court appearance is usually the first time that there's a guardian ad litem or court-appointed attorney involved. You're going to continuously assess and collect, what does this family need? What are the allegations of neglect and abuse? What are there people who are dangerous in the home? What is the family's environmental neglect or, lack of supervision? And then organize the evidence, organize the parent's completion task, communicate with the agency as to how that parent's completion is to be reported. And of course, as I say, in every training, document, 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 ask questions, take notes, ask for references, ask for the next steps, record all meetings, submit all summaries and reports. I highly recommend after team meetings, the parent write their own report. I used to write them, I'd call it the mother's court report. And I would have the mother write up what happened in the team meeting, what she was instructed to do, who spoke, who seemed, and even the attitudes and their responses in that meeting, and file it with the court. If they can file a court report, so can the parents. All right, so how the advocates work in the legal arena. These are things I will tell you over and over in different ways and different thoughts, but I have done this for 28 years, 30 years, really. And because I have done it so much, sometimes I forget that people kind of forget the process and how they have to constantly be tuned in to where they are in the process. So step one is understanding the parent and the facts, and in the documentation and taking notes, write down the people's names, write the children's names, write their dates of birth, write down the names of the caseworkers. If they don't have the names of the caseworkers, tell the parent you need to call the office and you need to find out who that is. We want to know who every single person is and what access they have to the case. Step two is to grasp the status of where they are in the process. And step three is analyze what can be done next all the time. And this is over and over. This part right here is repetitive. You think you understand the parent and the facts, you try to get a hold of the status, you analyze what to do next. And often, even in the very same case, you end up back at step one because it's cyclical, because there will be changes that occur. There may be new people that become involved. There may be a relative pop up. So it's always understanding the parent and the facts, finding out what the status is, analyzing what can we do next, and keeping the progress moving forward. And most important, of course, through this whole process is be as knowledgeable as you can possibly be. Now, why advocacy? The parents are cast into administrative and legal systems that they cannot understand. Most of you have probably dealt with this system in some manner, and the parents are already vulnerable, and the state agency and other players will manipulate the parents with legalism. So you have, the court at the top. I'm not sure if the court's at the top. There's some reasons, some things, times the state agency's at the top, but the parent is at the bottom of this totem pole. I talked about this in the players, politics and players training. The parent is sitting at the bottom, and the parent is the one who has parental rights. And they are the one who are most apt to protect the child and protect the child's relationship with the parents and the family. So you have the courts and the state agency who immediately start taking control of that life. Now, in just an example in who's in charge, I had a state representative get involved in a case because the state would not return a child to the parents after the parent had completed everything. And the Department of Children's Services told the state representative that they had no control over that, that only the judge could return the child to the parent, which is absolutely false. Absolutely false. They can do a trial home visit. They can start a reunification. They can even drop their petition, which I've had them do. So so the parents' vulnerability is what we are trying to always attend to. And then in coaching parents, when you coach parents, just generally, in addition to the trainings, and I recommend we just try to turn some of them onto the trainings, they're not, a lot of parents are going to be very excited in a bad way, anxious, right, and frightened. But teaching them right away how to document, how to record, how to ask questions, how to keep all communication, how to find supports, and how to engage family. So recording and asking questions is a very important part of it. And I have found that parents are not even being allowed to ask questions in the courtroom. So, try to continuously try to encourage a parent, if you don't understand something, to ask the question. And if they say your attorney will explain it to you, then look at your attorney, right? And, look at them until they nod their head that they will do that. Or if they don't explain it to you, the next time you go to court, tell the judge, your attorney did not explain that to you. Parents have got to be brave enough to ask the questions. All right, so keep up the good work. We are all on our way to creating an army of family advocates. I appreciate everybody so much, just your time, your attention, and just caring enough to jump on with me on Friday afternoon. As I have said, I know I don't have you participate directly in the trainings because if I get distracted, I will never get back on track. However, as we go and we continue to develop, our next level will be actually have work sessions, okay? And then probably some safe space sessions as well. So y'all are awesome. I am going to stop our recording and then we will have some discussion. I appreciate y'all being here.